This program is brought to you by Emory University.
Good morning, everyone. My name is Sophia Priola, and as many of you know, I'm the current Executive Symposium Editor for the Emory Bankruptcy Developments Journal. I'd like to welcome you all to the Emory Bankruptcy Developments Journal 11th Annual Symposium. As many of you know, this year marks our 30th anniversary as a journal, and I'd like to take this opportunity to thank the people who not only helped start the journal, but have helped it thrive and to grow over the past 3 decades. Specifically, I'd like to thank the Southeastern Bankruptcy Law Institute, Dean James Elliott, Professor Charles Shaner, Professor David Epstein, our alumni advisor, Keith Shapiro. I'd also like to thank our past faculty advisors, such as Frederick Tung and Ralph Brubaker. Our current faculty advisor, Professor Rafael Pardo, for who over the last 2 years has been such a great help to this journal. Also, the current Dean of Emory Law School, Dean Robert Shapiro. And of course, all the others who have helped us over the years. Before we move forward with our first panel, I'd like to invite Dean Shapiro to the stage to say a few words.
Well, thanks very much for all of you being here today. Thanks very much for our panelists who traveled from near and far. I'd also like to thank our sponsors. Please note their names on the poster outside. We certainly appreciate all of their support. Now this, of course, would not be possible without the hard work of all the students on the Emory Bankruptcy Developments Journal, so I'd especially like to thank them, and especially among them, the Executive Symposium Editor, Sophia Priola, and the Editor-in-Chief, Alex Clayman. Now at Emory Law School, we emphasize a curriculum that integrates theory and practice, and we seek positive transformation through the ideas we create, the students we educate, and the service we perform. And our bankruptcy program is central to this mission. It brings together the academy, the bench, and the bar. It provides practical experience for our students, and we hope it provides illumination and guidance in law reform efforts. And for 30 years now, the Emory Bankruptcy Developments Journal has been at the heart of this bankruptcy program. Now, part of the bankruptcy program, of course, is the journal that we put out every year. It's also these wonderful intellectual events such as the Symposium today, looking at issues like Section 363 and lien stripping. Now, I hope you allow me a little personal reflection here on the importance of the journal. I'd like to take you back to August 1991. There were 4 recent law school graduates sitting around. They were law clerks for Justice Stevens. I was among them, and it was time to divide up the cases that were going to be argued in October of the October term 1991. There were 20 cases. We went through a kind of draft system. There were 4 of us. We go through 1 round, the next round 5 rounds. I think the first round, maybe it was the Bray case was chosen, which was about the application of civil rights laws to abortion protesting. There was the Simon and Schuster case about Son of Sam law in New York, whether New York could take the proceeds when a criminal published a book. There was the Chip Alone case about whether people could sue tobacco companies for the harm caused by cigarettes. There was Freeman versus Pitts, a desegregation case out of DeKalb County, Georgia, and round it went. Now, then there came up this interesting bankruptcy case out of the 10th Circuit, Dewsnup versus Tim. Now, I don't remember if it was the last case chosen, but I think it was in round 5. And then in October, the case was argued, and it was clear that perhaps the justices were having a little trouble with the case. I was looking back at the oral argument transcript. One of the questions began with a somewhat unpromising beginning question. I'm a little dense on this, counsel. So the court, I think, had a little trouble with the case. And of course, the clerks did not have the benefit. None of us had been on the Emory Bankruptcy Developments Journal to get the illumination that this would have offered us. So the opinion was issued, and I know it was eventually subject to certain academic criticism. I believe one of the members of today's panel have talked about it as a historical anomaly, a deviation from consistent practice. I've been told that one of our panelists is going to describe the case as the worst decision ever rendered by the United States Supreme Court. So, all of this is to say that the important work that the Emory Bankruptcy Development Journal will do to make sure clerks of the future are better educated and won't make this kind of mistake, and also with the Law Reform Project, as illustrated by the symposium today, to clean up all the mistakes made by judges and by clerks in the past. So with that, we look forward to an outstanding program. Thank you so much for being here, and thanks again to our panelists.
Thank you, Dean Shapiro. At this time, I'd like to welcome our first panel, our consumer panel. This morning, we're very pleased to have Professor Lawrence Poneroff present his article entitled, "Hey, the sun is hot and the water's fine. Why not strip off that lien?" Professor Poneroff's article is published in our current issue of the journal, which is at the printer right now. Professor Lawrence Poneroff is the Samuel M. Fetley Chair in Commercial Law at the University of Arizona James E. Rogers College of the Law, where he also served as dean from 2009 to 2012. Prior to joining the Rogers College, Professor Poneroff was the dean of Tulane University Law School in New Orleans. Formerly, Professor Poneroff was a partner with the Denver-based law firm of Holm, Roberts, and Owen, which is now Bryan Cave. Professor Poneroff is the author or co-author of numerous law review articles, as well as 5 books in the areas of business and consumer bankruptcy, contracts, and commercial law. He is served by appointment of the Chief Justice of the United States on the Advisory Committee on Bankruptcy Rules to the U.S. Judicial Conference and the Bankruptcy Judges Education Committee of the Federal Judicial Center. A graduate of Stanford Law School, and he is also a member of the American College of Bankruptcy. Responding to Professor Poneroff's article today is the Honorable Thomas Small and the Honorable Mary Grace Steele. Judge Thomas Small serves as a United States bankruptcy judge for the Eastern District of North Carolina. Judge Small is a former chair for the U.S. Judicial Conference Advisory Committee on Bankruptcy Rules and was president of the National Conference of Bankruptcy Judges in 2000 and in 2001. In addition, Judge Small has been a member of the Collier on Bankruptcy Board of Editors since 2007 and a member of the National Bankruptcy Conference since 2006. Judge Small served as the vice president and associate general counsel for First Union National Bank, now Wells Fargo, from 1969 to 1982. He received his Bachelor of Arts from Duke University and his Juris Doctor from Wake Forest University School of Law. Judge Mary Grace Steele, also responding this morning, was appointed to the Bankruptcy Court for the Northern District of Georgia in February of 2004. Prior to that time, she was a partner at Troutman Sanders, where she chaired the bankruptcy practice group. She received a BA in History, summa cum laude, from Canisius College in Buffalo, New York, and her JD cum laude from Harvard Law School. Judge Steele has chaired the bankruptcy sections of both the Atlanta Bar Association and the State Bar of Georgia. She is a fellow and vice president of the American College of Bankruptcy and a former president of the Southeastern Bankruptcy Law Institute. She received the Woman of the Year Restructuring Award in 2008 from the International Women in Restructuring Confederation. She is on the board of governors of the National Conference of Bankruptcy Judges and served as education chair in 2009. She is on the Certification and Education Oversight Committee of the Turnaround Management Association and a member of the board of directors of the American Bankruptcy Institute. Moderating today, we have Miss Beth Ann Harrell. Beth Ann Harrell serves as law clerk to the Honorable Paul Bonnetfeld. Ms. Harrell graduated magna cum laude from the University of Tennessee with a BA in History and Religious Studies and received her Juris Doctor from Emory University School of Law. She is a member of the State Bar of Georgia and Atlanta Bar Association and serves on the Advisory Committee Board for the Emory Bankruptcy Developments Journal. At this time, I'd like to turn it over to her. Thank you.
Thank you, Sophie. Let me just tell you all a little bit how we're going to proceed. Professor Poneroff is going to present his paper, take about half hour or so on that, and as Sophie mentioned, Judge Steele and Judge Small will respond. I'll have questions for everyone, but before we get to the questions, Judge Steele will kind of give a rundown of what the state of the law in the 11th Circuit is with respect to lien stripping in Chapter 7 cases and Chapter 13/20 cases. So I will turn it over to Professor Poneroff at this time.
Thank you. I indicated to the tech people I don't sit that tall in the saddle, so I thought I would present from up here. First of all, I sincerely, Sophie, thank you for the nice introduction, and I want to very much express my appreciation to the board and the staff of the Emory Bankruptcy Developments Journal, Alex Clayman, the editor-in-chief down there. They've worked very hard, done a terrific job in pulling this symposium together, and they did a fabulous job editing the article that I'm about to present, particularly given what they had to work with to start with. So thank you very much. I appreciate it. I think they deserve a round of applause. Now, as indicated, the premise of that article is really a very simple one, and that is that strip-off of wholly underwater liens ought to be permitted in Chapter 7, although so far only one of 4 circuit courts to date, the 11th, has agreed with me on the point. In that case, McNeil, as I'm sure many of you know, is not necessarily yet final. As was indicated, Judge Deal is going to speak, I think, in much greater depth about the state of the McNeil case and the law in the 11th Circuit generally. So let me go back to the article, because while the premise of the piece may be simple, the rationale for it is more nuanced and I think more important for the bankruptcy system. It has several parts, but 3 of which are most critical. First, secured creditors only exist under state law. There is no such thing as a secured creditor in bankruptcy. Second, bankruptcy entails a closing of the books on the debtor's pre-petition life in a way that has no analog under state law. And third, Steen Shapiro indicated, my view, that Dewsnup versus Tim was indeed the worst decision in the history of the Supreme Court of the United States. Okay, I know, Dred Scott was pretty rough too, but Dewsnup was really, really bad. So, allow me to address, if I may, these points in order. As you well know, first in Section 101 of the Code, the terms claim and creditor are defined terms of art. The phrase secured creditor or secured party is nowhere to be found because that creature does not exist in bankruptcy. Now, Section 506A1, of course, differentiates the extent to which a creditor's claim will be regarded as secured or unsecured for purposes of the bankruptcy case, but it does not do so based on the existence of a piece of paper that state law calls a security interest. Rather, the code says, of course, a creditor who holds a claim actually supported by a state value is a creditor with a secured claim to that extent. Not a secured creditor, a creditor with a secured claim to that extent. Otherwise, you hold an unsecured claim. In other words, secured for bankruptcy purposes is a function not of the identity of the creditor, but rather it's a function of the status of the claim as determined under 506A1. Now, this is quite different, of course, from what it means to be secured under state law. But it is this difference that highlights the essentiality of bifurcation to the accomplishment of the goals of a bankruptcy proceeding separate and apart from state law. Which brings me to my second main point. If it's to provide any meaningful relief at all to the debtor and to creditors as a group, bankruptcy demands that all pre-petition obligations be accelerated, adjusted, and accorded the treatment called for under the code, right? Hence the broad definition of claim in 1015. At its essence, bankruptcy is a process designed to allow a beleaguered debtor to resolve all of her debt obligations in a single expedited proceeding. It is the very point of bankruptcy to cleave a wide chasm between the debtor's pre- and post-petition life, so as to close the books on all but a very select handful of pre-petition obligations that are accepted from the discharge either because of opprobrious debtor conduct or competing policy interests. Beyond that, allowing creditor appropriation of post-petition value runs directly counter to Fresh Start policy, a phrase that appears nowhere in the Bankruptcy Code, but which the Supreme Court, as late as 2007 in Citizens Marama versus Citizens Bank of Maryland, told us is the principal purpose of the Bankruptcy Code. And let me stress that these issues about the proper characterization of secured debt in bankruptcy are not simply individual creditor versus debtor issues, which is, of course, the fashion in which state law apprehends the matter. Bankruptcy, as you know, by contrast, is also concerned with the rights of creditors inter se. So a conceptualization of security that insists on minimizing to the point of triviality the infringement on state law rights undermines the equality objectives of the system as well. In other words, allowing undersecured creditors to enjoy post-petition appreciation must come from somewhere, and it comes at the expense of other unsecured creditors, and thus runs directly counter to the bankruptcy goal of equality of distribution among similarly positioned creditors. Now, ironically, I think the hanging paragraph following Section 1325A9, 1325A asterisk, which prohibits the strip down of certain purchase money loans in a Chapter 13 plan, I think that paragraph underscores the point about the centrality of 506A1 in defining what it means to be secured. Now, I say ironically because, of course, the hanging paragraph came in with BAPSIPA. And BAPSIPA has been accused of many things. But strengthening the hand of consumer debtors has never been one of those things. Nevertheless, while doubtless this provision was intended largely to benefit the financing subsidiaries of major automobile manufacturers and other financial institutions regularly engaged in secured auto lending, what is telling for our purposes is how Congress went about achieving that aim. How did Congress do it? By decommissioning the operation of Section 506A as to those loans. The effect of doing so is that a claim now, as defined in the hanging paragraph, must be treated as fully secured for purposes of 1322B2, can't be modified. My point is that implicitly, this is a congressional reaffirmation that a allowed secured claim, as used throughout the code, derives fundamentally from the meaning assigned in 506A1, Dewsnup notwithstanding, unless that provision is made inoperative by Congress. while other code provisions then may determine in a specific context what may or may not be done to those claims, the point is these claims owe their existence in the first instance to 506A. And this then helps to explain the third major point, why Dewsnup was such a terrible decision. Now, I don't make this assertion based solely on its Alfred E. Newman-esque approach to statutory construction. In holding that the phrase allowed secured claim under 506D means something quite different than the exact same phrase in 506A. Rather, I make the assertion because that holding, if it had been broadly interpreted and applied, could have desiccated the bankruptcy system. Now, fortunately, the Supreme Court's own statement that its holding was limited to the facts presented in the case and that it would allow other facts to await their legal resolution on another day has allowed the lower courts to mitigate the worst harms that Dewsnup might have wrought. But I'd submit we can go even a step further. Now let's look at how Dewsnup has been tamed, if you will. Initially, as I'm sure you know, the lower courts quickly found a basis to continue strip-down modification of partially secured claims in reorganization cases, notwithstanding Dewsnup, based on the existence of alternative statutory authority to modify secured claims in those chapters. Next, courts gradually came to what is now the widely shared consensus that even though stripped down of undersecured residential mortgage claims is barred under 1322b2 by the Supreme Court's Nobleman decision, this does not preclude the strip off of subordinate liens for which there is zero current equity in the property. And indeed, it was language from the Nobleman decision itself that allowed for this result, strip off in Chapter 13. And that was the language in the case that said, for the anti-modification provision in 1322b2 to apply, the creditor must have a secured claim to some extent, and then its rights are protected. But it must have a secured claim to some extent, with secured defined by the Supreme Court in Nobleman, decided 1 year after Dewsnup in the traditional 506A1 fashion. Now, of course, in the case of a wholly undersecured lien, the limitation in 1322 against modification is therefore not applicable because it's not secured in any sense. Hence, strip-off of wholly underwater liens in 13 is pretty widely accepted. Okay, the next step was in 2012 with the First Circuit Court opinion to address an issue that has split the lower court. This was the decision in Emory Davis from Judge Small's circuit, the Fourth Circuit, which has now permitted strip-off in Chapter 20. Notwithstanding 1325A5B, which says, in the case of a secured claim, the plan, in order to be confirmed, must provide for retention of the lien until either full payment or discharge, neither of which will occur in a Chapter 20 case, since discharge is now precluded under 1328 F1 if, of course, the debtor received a discharge in Chapter 7 within the preceding 4 years. So the trustee in Davis made the argument that you can't strip off because of 1325A5B, and then also argued in the alternative that strip-off should be denied in Chapter 20 cases because it would represent an end run around Dewsnup, as if end running Dewsnup is a bad thing. The Davis court rejected both arguments. As for the language in 1325A5B, small Roman I, and that's nothing, 1325A5 now goes down past small Roman I to uppercase Roman to double lowercase Arabic letters. Thank you, Bapsipa. The court concluded that the language saying the creditor has to retain the lien until full payment, which isn't going to happen, or discharge, which isn't going to happen in a 20, the court concluded, well, yeah, that's true, but that provision, by its terms, applies only to a creditor with an allowed secured claim. And how do we determine that? Duh, under 506A1. And that, of course, would exclude a wholly underwater lien, which does not have a secured claim to any extent. Basically the same analysis that has caused courts pretty uniformly to distinguish noblemen in the case of strip off of an unsecured lien versus strip down of a partially secured lien in 13. Now, as for the end running or violating the spirit of Dewsnup argument, and the Fourth Circuit, unlike me, has to take the Supreme Court seriously, the court in Davis observed, well, look, if the filing is really an abuse of the bankruptcy process undertaken, the debtor really has no need for restructuring her debt. This was undertaken solely for purposes of stripping off the underwater lien. The court said, look, there's an adequate response in the good faith requirement of 1325A3, and that's your remedy. Pretty much the same approach that the Supreme Court took way back in Johnson v. Home State Bank when it first sanctioned use of Chapter 20. The point is that the fact that in Davis, what the debtor had done in 2 steps was that which was precluded from being done in 1 step by Dewsnup was not, according to the court, sufficient reason to bar strip-off of the lien. You know, in sum, Dewsnup's astonishing and nonsensical interpretation of the phrase allowed secured claim in 506D posed such a pernicious and far-reaching consequence in areas of the practice well beyond strip down that the only way to tame the decision was to ignore it. And for the most part, that's precisely what the lower courts have done. In a case decided a couple of years ago in Ray Woolsey out of the 10th Circuit, the court observed, and I'm quoting here, Dewsnup has lost every game it has played. Its definition of secured claim has been rejected time after time. Davis now is just the latest nail in the coffin. And next, I'm advancing the proposition that we take the next logical penultimate step, which would be not to apply Dewsnup to strip off, as opposed to strip down in Chapter 7, as well as 13 and 20. Now, parenthetically, if the 11th Circuit's panel decision in McNeil is upheld en banc, an added benefit would be that this will create a split in the circuits on the issue that could provide the opportunity for the Supreme Court to revisit and clarify its ham-handed interpretation of allowed secured claim in 506D. But that's for another day. I'm just talking about strip off of a wholly underwater lien in Chapter 7. Now, surely the judges on the panel this morning will point out that strip down or strip off can only occur in the claims allowance process, and that, as you well know, in most Chapter 7 cases, there are no assets to administer and thus no claims to allow or disallow. Thus, I believe they will point out that the determination of secured status is kind of meaningless in Chapter 7 unless the trustee proposes to sell the putative collateral. But, respectfully, last I checked, the provisions of Chapter 5 apply in Chapter 7, and even Dewsnup agrees that 506D avoids a lien when the claim it secures is not allowed, whatever that means. So, if the debtor files a motion seeking strip-off of an unsecured lien, I think a claims allowance process and valuation must occur. You know, the majority's reasoning in Dewsnup relied heavily on what it termed the pre-code practice under which liens pass through bankruptcy unaffected. Almost like a kidney stone, I guess. But the Supreme Court itself, as recently as 2012 in the Radlax decision, has repeatedly held that pre-enactment practice is relevant only to the interpretation of ambiguous text in the code, which 506D clearly is not. Moreover, the notion that liens pass through bankruptcy unaffected is simply not true under the code, nor was it true under the former act. The more accurate statement would be that liens pass through bankruptcy unaffected to the extent that the bankruptcy law doesn't alter those rights. In other words, what goes into bankruptcy may be defined by state law, but what comes out may look entirely different. And the Supreme Court's holding in Butner does not, by any means, dictate that simply because a creditor's contractual and property rights are established under state law does not mean those rights cannot be affected in a subsequent bankruptcy proceeding when necessary to vindicate an important federal interest, such as fresh start and creditor equality, interests and policies that simply have no analog under state law. Furthermore, despite the suggestion to the contrary in the majority's opinion in Dewsnup, there is no unconstitutional taking when Congress regulates property rights prospectively, even if that regulation eviscerates a state law lien. That proposition, I think, is implicit in the Supreme Court's decision in U.S. versus Security Industrial Bank, the case you'll recall that upheld the prospective application of the lien avoidance provisions in 522F2, and similarly, the Dewsnup Court's reliance on the Radford case, a 1935 Supreme Court case that declared the Frazier-Lemke Farm Bankruptcy Act of 1934 unconstitutional. What the majority in Dewsnup ignored is the fact that once Congress amended that act to apply only prospectively and to assure the creditor of the current value of its collateral, the Supreme Court sustained the constitutionality of the Frazier-Lemke Act. In short, I would maintain that the Code's classification of claims under 506A1 is central, pivotal to the attainment of the purposive goals underlying bankruptcy. You know, except in those isolated instances where Congress has, wisely or not, explicitly prohibited bifurcation, as in the hanging paragraph, or a creditor has exercised its statutory option to avoid bifurcation, as under 1111B2, a debt secured by collateral that is devoid of economic value simply cannot be regarded as secured in bankruptcy. And this is so because once the debtor files bankruptcy, that creditor, that was a secured creditor under state law, is now simply a creditor, the nature of whose claim will be determined and then provided for under the code. It is the distinction between types of claims rather than types of creditors, as under state law, that is so essential to the accomplishments of the unique goals of the bankruptcy system. In other words, bankruptcy recognizes but does not hold sacrosanct every aspect of the creditor's state law bargain. What's constitutionally protected is the value of the lien. That's why we don't protect the equity cushion, and that's why we don't compensate lost opportunity costs. Now, rectification of Dewsnup's unorthodox reading of allowed secured claim is going to have to wait another day. But my point is that it is not necessary for that redress to occur before a lien that is wholly underwater can be stripped off, not just in Chapter 13 and 20, but in Chapter 7. And this is because in those situations, unlike the facts of Dewsnup, there is no secured claim. And if there is no secured claim, then the whole concept of lien becomes a non sequitur. You know, Dewsnup undoubtedly said the phrase allowed secured claim means something different under 506D than 506A. But it did not say 506A is irrelevant in Chapter 7. In order to be secured, a claim must be supported by some value, or Congress must have excluded the operation of 506A. Otherwise, this so-called lien holder is in substance really no different than any other unsecured creditor, and bankruptcy equality policy demands that that creditor then be treated as such. You know, we can argue as of when to value the collateral, although that's usually not much of an issue in 7. And we can argue in cases to which 506A2 does not apply. We can still argue over the method of valuation. But what I would submit is unarguable is that a security interest, only protectable property interest in bankruptcy is axiomatically its current value. So that if the measure of the collateral's value is $1 or greater than the sum of all prior liens, then a secured claim exists to that extent, and Dewsnup requires that the lien remain with the property even after the in personam claim has been discharged. Although it's rather difficult to imagine what purpose this serves other than to frustrate the debtor's fresh start without any corresponding social utility. But we can't help that. On the other hand, if the debtor successfully establishes that the value of the lien is 0, a determination that is hardly made in secret or ex parte, then there is simply no unsecured claim. And it's at that juncture that the lien becomes an unnecessary excrescence that should be amenable to strip off, if not under the language of 506D, which after all does refer to a lien that secures a claim, then conceptually under another power of the bankruptcy court to go beyond the literal text of the code. Now, the stumbling block for a lot of courts to taking that next step, I think, has been the absence of alternative statutory authority to strip off a lien in Chapter 7, such as exists in 13 and 11, in 1322B and 1123B5. So what I suggest in the article, no, I don't go running to Section 105. What I suggest in the article is that this authority might be found in an approach the courts have been engaged in, frankly, for over a century, namely, common lawmaking when necessary to serve important federal interests. Now, I know the conventional wisdom is that bankruptcy courts are not common law courts, and that actually there is no federal common law. But where, I ask you, is the statutory authority for substantive consolidation or discharge or release of non-debtor affiliates or critical vendor orders? Just like equitable subordination for 40 years, it doesn't exist. Until the doctrine was codified under the code, equitable subordination, like those other practices, existed because they were simply necessary to achieving the goals of the system. Now, this approach is not my invention. It was advanced by Adam Levitin in 2005 in a sort of inferior bankruptcy journal, the American Journal of Bankruptcy Law. And the article focuses on the relationship between Congress and the courts in bankruptcy matters. It does not purport to address the issue of the relationship between federal and state law. Nonetheless, I think the analysis has the potential to say a great deal about that relationship as well, inasmuch as we all know that the bankruptcy power, when exercised, is exclusively federal. And I also think that the lawmaking authority of the bankruptcy courts finds implicit congressional authorization in the decision made a long time ago to put bankruptcy proceedings where? Not in an administrative agency, as Professor Pardo would put them, but in a court. Now, what's the point of putting it in a court if there isn't an opportunity for judges to be judges? In sum, what I've tried to demonstrate is I think there is an avenue available for those courts, not bound by circuit precedent, that seek both a clear and principled path for further limiting Dewsnup even more narrowly to its facts. And its facts were stripped down of undersecured liens. Now, obviously, I believe that holding is also flawed, but only Congress or the Supreme Court can do something about that. In the meantime, I'd urge that strip-off in Chapter 7 is not barred by Dewsnup, that core bankruptcy policy demands that it be permitted, and more generally, that going forward, we be a little more attentive to what it means to be secured in bankruptcy. Thank you.
Thank you, Professor. I'm going to turn it over to Judge Deal.
As Professor Poneroff knows, the 11th Circuit actually is the only circuit that agrees with what he's saying. And I'm just going to take a minute to trace how we got there. We go back to 1989, which is pre-Dewsnup, and the 11th Circuit had a case called Fallen Door versus the Small Business Administration. And the holding of that case permitted a debtor to strip off a wholly unsecured lien in a Chapter 7 case. Now, the parties in that case stipulated that the SBA had an allowed secured claim. So the discussion in the case is not really about 506A, it's all about 506D, what's the result of that. So that case is out there, and then in 1992, the Supreme Court gives us Dewsnup, and the Supreme Court there is looking at 506A and 506D in the context of a strip down, not a strip off, and the debtor there was attempting to cram down the second mortgage on his house, and the court holds that he can't do that, no strip down. And the reasoning is a bit contorted because they end up saying, well, allowed secured claim means something different in in 506A and 506D, we have to look at each modifier separately. We have to ask, is the claim allowed? And then is there collateral for the claim? And they get there to that result. So that's in 1992, and really you don't have too much happening, I guess, because the market at that point is going up. So you don't necessarily have a lot of undersecured mortgages. But we do have, 1998, the Ninth Circuit BAP weighs in and says that you cannot strip off in a Chapter 7. Then the Fourth Circuit in Ryan in 2001 says the same thing. The Sixth Circuit in 2003 in Talbert says the same thing. They're all following Dewsnup. There's also a number of bankruptcy courts that apply Dewsnup not to allow strip off. But really there's very little law that's developing at that point in time. Then we get 2009 and we get the mortgage crisis, and we suddenly have a whole slew of second mortgages that are totally underwater. And the only circuits that have weighed in on that since then are the 11th and the 7th Circuit, which in 2013 has the Palomar decision, which again says you can't do the strip off. So we come to 2009, and Lorraine McNeil files her Chapter 7 case in the Northern District of Georgia, and she files a motion to strip off her second mortgage applying 506A and 506D. And the motion is unopposed. But Judge Bonifel nonetheless denies the motion, citing Dewsnup, and his opinion is in April of 2010. And he emphasizes, number one, there's no substantive difference between a strip down and a strip off if you apply the rationale of Dewsnup. Secondly, it would be a departure from pre-code law that liens pass through bankruptcy. And then he uses the Nobleman case, the 1993 Supreme Court case, to say that 506D doesn't bifurcate because Chapter 13 Nobleman uses 1322B2 to say you can't modify the rights of the holder of a secured claim. And he says 506 is not an independent vehicle to avoid the lien. It merely facilitates valuation and the disposition of property in reorganization chapters. So that was, I think, no one was really surprised that that was the result because we have all the circuits saying exactly that. So the district court affirms, and it goes to the 11th Circuit. And in May 2012, so now we're 2 years since Judge Bonifel reached his initial decision, the 11th Circuit reverses. And they rely on Fallendor and the prior precedent rule of the 11th Circuit. And they say, well, Dewsnup was a strip down, this is a strip off, it's not exactly the same thing, so Fallendor is still controlling. To add to the curiosity of it all, the opinion is a per curiam, and it's unpublished. And under the 11th Circuit rules, an unpublished decision is not binding precedent. It is merely persuasive authority. So, and then while this is going on, the lender in McNeil, which was GMAC Mortgage, files its own bankruptcy. So that throws the 11th Circuit in a tizzy because they don't know what to do because now they have another party in bankruptcy. In the 11th Circuit, the judges and the attorneys really sort of are in chaos because we don't have binding precedent, but we do have an opinion of a panel in our circuit that says that we can strip off in Chapter 7. And at the same time, these motions are coming up with very little opposition, probably because the lenders are underwater and they would have to basically re-argue McNeil. So the judges don't know what to do. I think finally we all started granting them if they were unopposed, and I think that's pretty much what the judges throughout the 11th Circuit have been doing. In McNeil, then, there is a motion for rehearing on bank and a motion that basically says, please publish this decision so at least we know what's going on. Those motions are stayed because of the GMAC bankruptcy. So this decision in McNeil comes out in, what did I say, May of 2012, right? May of 2012. So in March of 2013, I have an opposed motion on one of these, basically re-arguing the McNeil rationales. And so I wrote an opinion that basically said, I agreed with Judge Bonifel in McNeil, but I'm just a little bankruptcy judge, and I'm in the 11th Circuit, so I'm going to follow my circuit. And the parties then took a direct appeal to the 11th Circuit, hoping to get out of the procedural mess that was created by the bankruptcy of GMAC, and the 11th Circuit granted that. And so it's been up there now a year when they've granted the direct appeal with nothing really happening. In August of 2013, the 11th Circuit published the original McNeil case. So in August of 2013, we finally have binding precedent in our circuit. And they said, we see there's a motion for rehearing en banc, and we'll take that up after 30 days. Well, August, September, we're still waiting. But at least now we have a controlling decision by one panel. In the Malone case, my case that is on direct appeal, the parties have filed a motion for hearing en banc. Skip the panel, let's just go to the en banc hearing. That motion has been sitting there with no development. And then we have Judge Sacca has a case called Sinkfield. In that case, the parties sort of recognized they're stuck with, the bank recognized it was stuck with McNeil, and so the parties entered into a stipulated order granting the lien strip but preserving the appeal rights of the bank. And then they got, at the district court level, they did a joint motion to affirm the bankruptcy court so that they could get to the 11th Circuit quicker. That was signed. Then it got to the 11th Circuit, and somehow the 11th Circuit ends up denying the party's motion for an en banc hearing. So we've got these other two en banc sort of sitting there. We've got this one denied, but that did give the bank, which is Bank of America, the ability to file a petition for a writ of certiorari with the Supreme Court, which they did, and the Supreme Court has requested a response from the other parties, which is due tomorrow. And I'm told that when the Supreme Court asks for a response, that is at least some kind of preliminary indication that they're interested in looking at the issue. And of course, the basis is we've got a split in the circuits. We don't have an en banc decision, but we do have an 11th Circuit panel that goes a different way than these other four circuits. So, I guess we've got sort of two ways of getting a reconsideration of the whole issue at the 11th Circuit level. Oh, and I should say, there's also a whole bunch of these other stipulated cases that have now gotten up to the 11th Circuit where they stipulate in the bankruptcy court, they get the district court to affirm, and the 11th Circuit has consolidated all of those, and there's also a motion for an en banc hearing in those that was just filed in December. So there's a lot of different things going on that may lead to a reconsideration of the decision, but that's kind of where we are. I will say, meanwhile, back at the ranch, we're stripping liens in Chapter 7 daily. There's just an awful lot of these cases that are coming through, and as I said, very few of them are opposed. Now, of course, in a Chapter 7 context, and I'll get to this in responding sort of to the basic premise of Professor Poneroff, but in a basic Chapter 7 case, if you strip off the second lien, it doesn't really help you unless you have reaffirmed the debt on the first lien, because otherwise you're getting through, you're discharged, and we can get into whether you can ride through or not, but
Doesn't it ride through?
well, it doesn't. The law would say that, but if the lender doesn't take any action, you may be okay. But having said that, in both McNeil and my Malone case, there is not a reaffirmation agreement on the first mortgage. So, and most people going into bankruptcy are not current on their mortgages. So I really don't know what's happening in the underlying situation on those, and it may be the cases are open, there's still an automatic stay. The property hasn't been abandoned. But in any event, we're hoping that there's some resolution of this, and the 11th Circuit also does have the Chapter 20 lien stripping issue up there. But it seems to me if they're going to say you can do it in Chapter 7, it's real easy to say you can do it in Chapter 20. You could have done it that way to begin with. So
There won't be any more
there's
Chapter
no
20s.
end run
Yeah.
because there's a direct route to get there. So that's kind of where we are, and we're still sort of waiting to see what happens, but in the meantime, we do have this controlling precedent. I think just, and I know Beth Ann's got some questions, but I really wanted to address sort of the underlying premise that Professor Poneroff has with respect to 506A and D. And in my way of looking at it, 506 is not an avoiding power. It is really something that is used in the claims allowance process. 506A talks about an allowed claim that's secured. And in order to have an allowed claim in a Chapter 7 context, you have to have a proof of claim. And if there's not a claims allowance process going down, you just never get to 506 in the way that I look at it. And I think the Seventh Circuit case, the Palomar case, which is the most recent circuit affirming that you can't strip off in Chapter 7, really does a good description of what 506D means and what it's Judge Posner, and he says, and it is like McNeil, a unopposed strip-off of a second mortgage, and he said what the liens that 506D voids is one that is secured by a claim that is rejected by the bankruptcy court. It's not an allowed claim. In other words, somebody files a claim and it turns out that the mortgage has been paid, but they never canceled their lien. Well, they don't have an allowed claim, so their lien would go away. And in a Chapter 7 case, you don't have any claims filed. Secured creditors don't need to file proofs of claim in Chapter 7. And what 506A's bifurcation, Judge Posner says, is actually a pro-creditor statute, because what it does is it gives a secured creditor two claims: their secured claim and then their unsecured claim in addition to that. If we didn't have that bifurcation, they would not get to share in the pool of the unsecured creditors. And he says now in Chapter 13s we can have strip off, because part of the balance of all this Chapter 13 is that you have to have the Chapter 13 plan and there's payments and you're getting some benefit from all of that. And that just doesn't occur in a Chapter 7. So, you know, you can get hung up on the language and the sort of crazy reasoning of Dewsnup, but in my way of thinking, the whole 506, it just doesn't come into play in the Chapter 7 cases.
So really, you're stripping off these liens in Chapter 7, but you're a reluctant stripper.
Correct. That's what my Malone case says.
Okay, now, I'm convinced by Professor Poneroff I would be an enthusiastic stripper, notwithstanding the Ryan case in the Fourth Circuit. But it seems to me that Dewsnup really is limited. It's not a strip off, it's a strip down case, and I see that as a big difference. Secured creditors have rights, but really they're worthless. And as Professor Poneroff, he calls them hold-up value or enormous unbargained strategic leverage. Well, it seems to me the claim may not be disallowed under 502, but really it's worthless and should be disallowed as such by 506, and I think it could be voided under 506(6)D. And I would enthusiastically, if that doesn't work, also go to 105, and because it promotes the fresh start. Now, I used to be a banker, and I remember those days when we would take worthless guarantees on corporate debt, basically for leverage. And that's what these completely underwater third, fourth, and fifth mortgages are. And you can get rid of the worthless guarantees in Chapter 7. Why shouldn't you be able to get rid of these worthless third, fourth, and fifth liens in a Chapter 7? That's my take on it.
Well, why does a debtor want to keep a property that is underwater? If the first is more than the value of the property, the only reason for a debtor to keep that is because we're in an up market and the value's going up, and the debtor gets to realize that, as opposed to the lender who presumably made the loan when there was value. That may not be true, but...
You want to take away the debtor's future wages, too?
Well, you know, the reason you strip them in the 13 is because you are getting the debtor's
Well,
future wages in exchange.
You know, you might want to sell the house in the future, and if you've got completely underwater
How are
third
you
or
going to
fourth
sell it
mortgage,
with
you
it?
can't sell it.
Well, that means that the first is already more than the house is worth. We're presuming this. So how are you going to sell it
Well,
without getting an agreement from the lender, a short sale?
that's not all that uncommon to have these sales where you have that are sold at a reduced sold for less than the amount of the mortgage.
Well, again, you always have the ability of the first to foreclose out the second, and that's probably one of the reasons why people don't oppose these, is because they realize they're vulnerable, and if there's not a re-aff, they may well get foreclosed out very quickly.
Before I pose any questions, let me just point out that we do have microphones set up, and the panel is happy to take questions from the audience. Just if you will come up, and I'll recognize you when you come up there. Our panel obviously has got great things to say, and they've anticipated a couple of my questions already. But let's start with the fundamental notion of stripping off a lien in Chapter 7. We have mechanisms for stripping off liens or modifying liens in all chapters. We've got Section 522 lien avoidance. We have redemption of personal property in Chapter 7 and 722. We have modification provisions in the reorganization chapters. If Congress had intended for liens, wholly unsecured liens, to be stripped off in Chapter 7, why didn't it make it explicit in the code?
Well, it's, I'm not going to get into the business of trying to explain or understand why Congress does anything that it does in connection with the bankruptcy statute, or frankly, the Supreme Court. It's astonishing how many Supreme Court cases are bankruptcy or bankruptcy related, because I think it's a place for the court to serve some other objectives with nobody's looking. I think we have to simply take the code as it's written. If a creditor is wholly underwater, in terms of the real economic nature of what it holds, who is that creditor more like? The first mortgagor or other unsecured creditors? I mean, I want to reiterate, I'm not just up here with a bleeding heart for debtors. It is also a intra-creditor issue as well. And I mean, I suppose there's an argument, if there really is future appreciation and you strip the lien, that under 551, that's preserved for the trustee and the benefit of other unsecured creditors.
Well, of course, I think that the fact there isn't explicit avoiding authority is an indication that this is not what you're supposed to be doing. In Chapter 7 cases, I mean, you know, occasionally you do have an asset case, but if you have a piece of secured property that has liens on it that exceed its value, the trustee isn't going to do anything with it. He's going to abandon the property unless, again, he can cut some side deal with the lenders to get some fees into the estate, but that's really not the subject of this panel. So you're never going to have a situation where this is going to come into play, except for the second lien holder that wants to have an unsecured claim, going back to the Palomar method. If the trustee abandons the property, or the trustee somehow sold the property and didn't get the second lien holder paid, second lien holder could file a proof of claim in an asset case as an unsecured creditor. So then you're into the claims allowance process. But in a 7, you're very seldom going to have a situation where you are valuing property. In a 13 or in an 11, yeah, you got to do that for terms of treatment in the plan. The secured claim gets treated one way, the unsecured the other. But that's not what we have in Chapter 7.
You know, strip-off is done a lot of different ways around the country. They're all different kinds of procedures. And if you look at some of these opinions, some of them were brought as adversary proceedings.
Right, and we do it by motion here, but yes, some courts require adversary proceedings, and perhaps even in the Chapter 13 plan at some point, you're going to be able to do that.
That's
if we
right.
do the
Sometimes
model
it's done
plan.
in the
Yeah.
confirmation process in Chapter 13, but in Chapter 7, you're doing it by motion practice.
That's
and
what
most
we
of
do
these
here.
are uncontested, is that right?
Correct.
And if they are contested, then you have a hearing, and has there been a proof of claim filed or anything like that? Or
Well, usually at the hearing, the issue that people put up is the value of the property. The debtor says that, no, you're not under, the debtor says you're undersecured, the creditor says, no, there's some value there, so you can't strip me off. I've not had, and other than, the whole issue of you can't do this in Chapter 7, even though you have controlling law in the circuit, and that's why we get all these stipulated appeals. But the hearings really don't contest anything other than, hey, you got the numbers wrong.
Well, let me ask you about a contested one, because, value's the key then.
Correct.
And frequently, the cases I've had, they're usually pretty close as to at least the second mortgage, maybe not the third or beyond that. But,
Well, the ones that contest generally are pretty close.
And
if it's
what
real clear.
value do you use in a Chapter 7 strip-off? Do you use a liquidation value? Do you use a market value? What value do you use?
Well, normally there are appraisals on both sides and their market value.
Okay, even though Chapter 7, of course, is based on liquidation, you
Well,
don't use
but
a
when you're
liquidation.
talking about a house, there's really not that much difference between market value and liquidation
Well, you have to
value.
apply rash, don't you? It's real estate, so.
Right.
So it would be a replacement value, but isn't?
Yeah, but,
Is it
remember
rash
you
in
got
Chapter
that.
In a
13
home,
case, though?
Yes,
when you're,
but you have that infamous footnote 6 that says that replacement is not necessarily retail or fair market.
But don't you also have the section, maybe it's 506A, that it depends upon what purpose you're doing it for?
Yeah, absolutely, and I think that's a criticism of Rash, that was a strained interpretation.
but this
of
is
that
real
language.
estate, and
Right.
what I'm talking about, and that's a whole lot easier to do, I think, than when you're talking about personal property where there may be a serious difference between wholesale, retail.
Right, well, an automobile, you've got a liquidation value,
right.
you've got a replacement value, and, but,
But what I'm seeing on the houses, it's an appraisal, a market appraisal based on comparable properties, presumably in the neighborhood.
Well, and to your earlier point about what's the reason to do this unless you've reaffirmed the first because you're underwater, Judge, another reality that you have to take into account in addition to market value or liquidation value in the case of certain property, particularly a home, is sentimental value and the attachment that people may have to property, regardless of the fact that they're going to keep making payments on a first, the principal of which is greater than the current value of the home.
Well, that's a lot of what goes on in Chapter 13. It's why people want to keep their houses, but
Let me ask the professor, in Dewsnup and its progeny, the Supreme Court has really focused on, in their discussion of the rights and the liens of secured creditors, this notion of the bargained for rights between a lien holder and a debtor. Is that a fair, I guess, target to focus on, or is it a red herring?
No, I think that's really at the crux of the matter. And the Supreme Court waffles back and forth on this. As I think I mentioned, it's to what extent are we going or are we obliged by the Constitution to recognize the state law bargain. After Alican and after Timbers, I think we all understood that the only right that the creditor had, secured creditor had, that couldn't be altered in a bankruptcy proceeding was the right to the current value of the property. As I said, that's why we don't protect the equity cushion or provide lost opportunity costs. But when you read both Dewsnup and Nobleman, there is lots of language paying homage to the terms of the loan documents, the state law bargain of the secured creditor. And the Supreme Court goes back and forth on that, but, you know, subject to the Fifth Amendment, it seems to me that the determinant ought not be, you know, where we're going to put the fulcrum in terms of state law rights. And it ought to be, okay, we're going to protect your value. That's axiomatic. But beyond that, what we recognize or don't recognize ought to be driven, as it is in a lot of other contexts, by attainment of the goals of a bankruptcy process. And those goals are goals that simply don't exist as a matter of public policy under state law. So look at all the bargains we undo in bankruptcy. I see the court as unduly deferential, and as opposed to focusing on, well, was this part of the bargain, you know, the right to foreclose, the right to a deficiency, they ought to be focused on, okay, beyond protecting the current value, which would be a taking, how much of the bargain can we enforce without beginning to erode the goals of the proceeding?
But isn't there a fundamental difference when you're looking at that from a reorganization context, which I agree with you, we don't protect equity cushions, we don't require adequate protection of those, but we're talking about Chapter 7. This is not a process that is designed to leave the debtor with anything other than a discharge and exempt property, which is what I would say is the fresh start. Debtor gets a discharge, and the debtor gets to keep the property that's exempt, and to avoid liens on exempt property, our 522 situation. But what you're using the lien stripping to do, in my mind, has nothing to do with the fresh start, because if that property belongs to the debtor, subject to the two liens.
Which have no value.
But you're giving the debtor something. You're getting rid of a lien on property that's not exempt and letting him go, and we're not in a reorganization context. It just doesn't seem like that has something to do with the policy. We're mixing up the reorg policies with this.
Well, the fresh start is the key to Chapter 7.
Agreed.
And I just think it's more than what you say it is. It's an impediment to the fresh start. I mean, it's a big impediment. He's never going to be able to sell the house as long as you got that lien there.
Well, the house is not something he's entitled to keep in the Chapter 7 unless he reaffirms the debt on it.
Pretty essential part of his fresh start, it seems to me.
Well, let me pose a question from that, because, traditionally, in Chapter 7, a debtor has the ability to do three things with property: surrender, reaffirm, or redeem. And so where does lien stripping fit in with that, then? When we start considering ideas of post-petition appreciation of property and who the benefit should, come to, from a policy perspective, where does lien stripping fit in with that?
Well, again, I would simply reiterate, take the facts of Dewsnup, which of course is stripped down, but here we're talking about, larger policies, and I think Dewsnup is, stripped down ought to be permitted too. I just, can't figure out an argument to say that. But what are most lenders going to do as soon as the stay is lifted? They're going to, they're either going to get wiped out by a foreclosure of the first, or they're going to foreclose to recognize that value that the debtor was willing to pay. And the reality is that if we're valuing the property at market value, that's probably more than it's going to be garnered at a foreclosure sale. and there is the efficiency of avoiding the delay and the costs of that sale. So I really see no downside for that creditor other than one who says, well, you know, I'm a private lender, so I can keep it in my portfolio, and I think the property will appreciate, and someday I'll get more of my lien paid off. But you're unsecured with respect to the balance of that claim. You had an unsecured claim in the bankruptcy case, and that, you know, that notion of bankruptcy pulling a curtain down between the pre- and post-petition lives would cause me to argue that even if that post-petition appreciation is there, that it belongs to the debtor. And if I'm that, I mean, as Judge Small mentioned, what is likely to happen in the Dewsnup situation, if the debtor really can take care of the first, is after the court says no strip down, now the debtor, if the resources are available, goes to the lender and says, okay, what's it take? I know I can pay 120, but I don't want to do that, and my guess is you'll probably take less than 120. 49,000? You know, is that what we want to encourage?
What about the situation which is becoming increasingly common now where the debtor is able to do a modification of the first, which may involve a buy down of the principal? You know, it may be that the modified mortgage, suddenly the second, if it hadn't been stripped, is in the money.
That doesn't sound fair.
That's, you know, that to me supports this notion of you know, you don't strip off the mortgage and then leave the debtor with the ability to do whatever. I mean, this is a Chapter 7. I mean, again, if you're in a Chapter 13, I think it's a whole different ballgame, and certainly a Chapter 11. But in a Chapter 7, we're at a liquidation proceeding. And we're talking about a method that leaves the debtor with property subject to a lien that is that property and the what you've stripped off, there's not an exemption in that. So you're really creating a reorganization chapter that isn't there. Why do a 13 if you can get in the 7 and get rid of the second? And you're pretty current on the first.
Well, I think...
And you don't have to pay your...
But that's just one asset of the estate. I think there may be very good reason to still do a 13 in a lot of cases. And in point of fact, if the only reason to do the 13 is to deal with this situation, I think the better approach is, as long as you can get through the means test, is to deal with it in Chapter 7. And look, you know, where's the avoiding power is the big question out there. Well, you know, until 1991, everybody said, well, there's the avoiding power. Read 506D. Avoid, you know, a lien to the extent it doesn't support an allowed secured claim. So I hear you, and I think the point is well taken. But that's also part and parcel of the question of to whom does post-petition wealth belong? Now, there is another argument, which is as to why you would oppose strip-off, even though it's completely underwater, is based on a judicial valuation that maybe the lender doesn't buy into. And I get that one. But that's what we have courts for. You make your argument, you know, you win some,
But we're not
you lose some.
valuing the properties in Chapter 7 normally, except now that
Now
people
you are.
file motions to strip the lien, we may, you know, we have to when that's put in issue.
Let's turn to the Chapter 20 issue, and just for the benefit of the students in the audience who may have not heard that term before, a Chapter 20 is when a debtor has filed a Chapter 7 and discharged their personal liability on all their debts, and then thereafter files a Chapter 13, making it a Chapter 20, to deal with their secured claims or taxes, debts that were not discharged in the Chapter 7 case. So, Judge Small, we have a Fourth Circuit case from last year, the Brannigan case, which says that a debtor can, in a Chapter 20 case, can strip off a wholly unsecured lien on real property. If you can share with us, tell us what the impact of that is in your courtroom, and what are some of the issues that maybe the Fourth Circuit didn't anticipate from that decision?
One of the things I was thinking about was the timing of the strip-off. And it's interesting, in the opinion, the debtor proposed a plan that would strip off the lien upon completion of payments. Yet, I think the bankruptcy judge, Judge Lipp, went ahead and stripped it off immediately upon confirmation. And, of course, it springs back in the event that the plan is not completed. Well, what's the effect of having stripped it off? Well, maybe then you can sell the property, but maybe as a practical matter, you can't sell the property because if it's subject to a spring back, nobody's going to want to buy it if they're going to have these second and third liens coming back if the debtor doesn't complete the plan. But I was thinking about what are the consequences of modification of the Chapter 13 plan? Because after BAP-CEPA, a plan can be modified until all the payments are made by the trustee, the debtor, or any unsecured creditor. Well, there's a Fourth Circuit case called In re Murphy involving the modification, post-confirmation modification by a Chapter 13 trustee. The facts had a condominium that was worth $155,000, but it appreciated in value to $235 in 11 months. So it was a rather significant appreciation, and the trustee moved to modify the plan, and plan was modified, and the property was being sold, and the unsecured creditors got the benefit of that appreciation in the property. Well, let's say you have, in a Chapter 13 case where the lien's been stripped off, and you have the same appreciation, $155,000 going up to $235,000. Well, who can ask for modification of that? Well, I guess the trustee could. An unsecured creditor could, including the creditor. This is not a Chapter 20 case, but in a regular Chapter 13 case, I assume the unsecured creditor whose lien had been stripped off could file that motion.
Well, in your typical Chapter 13 case, the strip off of the lien doesn't occur until the discharge of the debtor, which is at the end of the case. I understand in a Chapter 20 context, we don't have the discharge, but we have the same timeline for modification.
Okay, so if that's the case, if the strip-off comes at the end, how could you sell the property? Because it's subject to the lien. And really, the only modification is for the benefit of the unsecured creditors, of which the stripped-off creditor is one, but that stripped-off creditor would have to participate in the appreciation with all the other unsecured creditors.
The cases are split about the timing, and I have a little bit of a discussion of that, a little bit because I didn't really understand it, about the timing of when the lien is stripped off. I think the Fizette case out of the Ninth Circuit BAP said at the conclusion of payments under the plan, completion of the plan, but you're right. In Davis, at least it appeared to me as I read it, that the strip-off was immediate with the spring back right under 340.
Okay, well, let's think about Davis. In a Chapter 20 concept, you have the appreciation of the property. Who can file the motion then to modify the plan? The trustee can. Right. Any other secured creditor can, and there were other unsecured creditors in the Davis case. But what about the stripped-off creditor?
Well, at least in our district, that stripped-off creditor is generally treated as an unsecured. The plan provides that they have an unsecured claim.
But except their claim had been discharged in the Chapter 7 case, and they no longer have an unsecured claim.
Well, they have an unsecured, I mean, again, I don't know that this is very sophisticated rationale, but a claim is either secured or unsecured. There aren't any other kinds of claims in the bankruptcy code. I mean, priority claim is an unsecured claim. I mean, so if you don't have a secured claim, then you've got to have an unsecured claim.
Well, I think
So-
they would have an unsecured claim, but it would have been discharged in the prior bankruptcy.
But
so-
Johnson v. Home State says they have a claim, so the
Right, that's
claim has
right.
got
You
to
can still
be
restructure.
unsecured because it's not secured.
Right. Well, these are interesting questions, and it may be that if there is appreciation, and unless the debtor is willing to sell the property, then as a practical matter, I don't think you can force them to sell the property, and it maybe makes no difference whether the strip-off occurs at confirmation or after the completion, because you're not going to be able to sell the property anyway as long as the lien can spring back.
Well, unless you get the lienor to agree to
That's right.
release the lien, which most lenders will probably not do out of the goodness of their hearts.
Exactly.
So,
Well, you have that same issue with respect to timing of the strip-off of the lien that comes up in Chapter 20. When you're not going to have a discharge, there's obviously other reasons that debtors don't get discharges in 13, such as they had a prior Chapter 7 discharge within the statutory period, or they don't file their personal financial management certificate, or haven't complied with 522Q. And so all those are cases where, if your lien strip order says that this is effective upon discharge, then what happens when there is no discharge?
Well, there's another interesting issue when you have the Chapter 7 followed immediately by a Chapter 13, and you really don't have any other creditors except in Davis. That's what basically happened. She filed the 7 and then filed the 13 a week later, but she was dealing with tax debts, and they didn't really raise the issue of good
Good
faith
faith.
there.
well, I'm sorry, go ahead.
No,
Judge.
you can.
Well, I was going to say, you're right. I mean, Chapter 20 colloquially used to be understood as the rapid-fire filing of the 13 as soon as the 7 was closed. After BAPSIPA with 1328F1, we now sort of have a 4-year temporal boundary around what's a Chapter 20. A Chapter 20 is any time you file within 4 years of receiving a discharge in Chapter 7.
Well, you also have that other temporal argument about how long you have to be in Chapter 13, and where you've discharged all the debt. You don't have any debt, but you've got a stripped-off lien. Do you have to keep the plan open for 5 years because there's a possibility of some appreciation in the stripped-off lien?
Well, it's what your applicable commitment period.
Right. Right.
Unless we have some questions from the audience, and feel free to come up. I do want to pose one question to the panel and get their input if they have any thoughts on it. If and when one of these issues gets up to the Supreme Court and they take cert, whether it's on the Chapter 20 issue or stripping off a wholly unsecured lien in Chapter 7, can they reconcile Dewsnup with other cases, whether it's Johnson or Nobleman, or do they have to go back to and write on a clean slate, or should they?
Well, I mentioned earlier Dred Scott, and the Supreme Court did acknowledge that it got it wrong. So I honestly don't see how you reconcile that. And that Woolsey case from the 10th Circuit is a great discussion of how, and the language is really lovely, but it's a great discussion of how, this just sticks out like a sore thumb.
I would agree with that.
Well, I mean, again, I think the reconciliation has got to come in terms of viewing liquidation different than reorganization, notwithstanding the fact that Chapter 5 does apply in all kinds of cases. I still think that whole claims allowance thing makes Chapter 7 different for these purposes?
I think this whole lien stripping, strip-off thing, I mean, it's basically a Chapter 13 issue, and I think a lot of the problems could be solved if they allowed bankruptcy judges to modify mortgages on the home residences. But, and I wish they had done that earlier. I think we would have come out of the recession a lot sooner.
Do you have any questions from the audience? Well, I want to thank our panelists. It was a fantastic discussion, and I strongly encourage everyone to read Professor Poneroff's article. It is excellent. You will learn very, very much. I know I did. And I think Alex has some remarks to make at this point.
Professor Poneroff, Judge Deal, Judge Small, Ms. Harrell, thank you so much for that fruitful discussion. Good morning, everyone. My name is Alex Clayman. I am having trouble with how short this microphone is.
It's fine for me.
Okay. I am the editor-in-chief of the Emory Bankruptcy Developments Journal this year. We're glad to have everyone with us. Before we proceed to the corporate panel, we're going to take a brief pause and have a break. We do have drinks and snacks waiting for you outside in the atrium if you'd like to make your way out there at this time. And we'll keep the break brief and reconvene in about 10 minutes. Thanks.